Hi, everyone, and welcome to Potter Clarkson's podcast, The Innovation Game. It's the second in our series of podcasts. Potter Clarkson is a leading European IP firm, and I am an IP solicitor. I'm very pleased to be joined today by Emmy Hunt and Harrison Lee. Emmy's a partner in the trademark team in Potter Clarkson, and Harrison Lee is a senior associate in that team. And we have got together today to talk about a recent case which has just come out from the General Court regarding trademarks for monopoly. Harrison, I know you've read the case in quite a lot of detail. Can you give us a background on the case and tell us what it's all about?
Thanks, Mark. Before I go on to the case, I think you might have given me a unintentional promotion there. I should probably just clarify that I'm an associate at Potter Clarkson. However, back to the case. So the case involved Hasbro and relates to one of its registrations for the trademark Monopoly. Hasbro was appealing the partial revocation of its registration, given that the EU Intellectual Property Office had previously determined that the mark had been registered in bad faith for what is known as evergreening. It should be recalled that in the UK and EU, trademark registrations benefit from a 5-year grace period before they can be challenged on the grounds of non-use. Evergreening is the practice of circumventing the requirement to file proof of use by filing replacement applications for the same mark and the same goods and services in order to constantly keep the registration within a 5-year grace period. In upholding the earlier decision of the EU IPO, the General Court made some really interesting points, including, whilst refiling is not in of itself prohibited, it can be an indication of bad faith. Even a short extension of the grace period, in this case it was 8 months with respect to some of the goods, can constitute bad faith. Hasbro's arguments that refiling introduced efficiencies beyond simply overcoming the requirement to file evidence of use were not deemed to be persuasive. In fact, the General Court took the view that, if anything, refiling led to more administrative burden, more marks to maintain, pay renewal fees for, etc. And a final interesting point was that the court took account of Hasbro's enforcement practices. They essentially noted that Hasbro had successfully opposed some third-party trademarks on the basis of this new registration, and that they succeeded because the new registration could not be put to proof of use. All in all, I think it's a really interesting case that could have some big implications going forward.
So did they give Hasbro an opportunity to, in effect, show that they could have proven use for those older marks, and therefore the purpose of the new filings wasn't in order to avoid, or just to avoid, the need to prove use in those marks and evergreen by introducing new marks onto the register?
So it didn't really come down to whether they could prove use of those marks. In fact, I think they made quite the bold claim in defence of their registration that it would be it's almost a preposterous suggestion that they hadn't made use of the monopoly mark in respect to board games and the like. They're given, it's one, in their words, one of the most well-known games in the world. So they were quite bold in making those statements. But I think what counted against them is probably sort of the last point made, that actually there'd been some cases where they'd succeeded on the basis of the newer registration that couldn't be put to proof of use. And that, I think, counted particularly against them. It's also important to note that bad faith comes in from the point of filing it. So bad faith takes effect. The new registration means at the point it was filed, it can't constitute being in bad faith. So therefore, you can't sort of recover that position by saying, but we could have provided proof of use. Not with respect to the new registration, that is.
Absolutely understood. I suppose in my head, I thought if Hasbro could have shown that they had that proof of use available, then it would have helped support their argument that their motivation wasn't to avoid collating proof of use information. But I take the point. Emmy, it feels to me that two things. One is evergreening is common, but this is what people do, and maybe that it is more likely where brands such as Monopoly are very confident in their reputation, that maybe they are more likely to take their eye off the ball in relation to proving use. Everybody knows Monopoly, so they forget to put the effort in that's needed.
I think that's true. I think some of it is that they're economising on having to collect and order what would probably be quite a large amount of evidence. There is a administrative burden that goes with it. And it's interesting, actually, that Hasbro, in their pleadings, they said that the filing strategy that they had followed in evergreening was common in the industry, and that they'd acted on the advice of counsel in refiling their trademark application. So it does raise some interesting implications in terms of what we as advisors recommend to clients in terms of those filings, if it's then going to be questioned in these types of proceedings. But I think it's in terms of whether it is a common filing strategy, I think it has become more commonplace. And I think it does raise some interesting questions, doesn't it? Because the trademark register is, I think, as we're all starting to experience, is becoming very, very cluttered. There's a huge number of marks, particularly in certain classes, and it's very, very difficult for new entrants into the market to register trademarks and to create new brands. And I think that the evergreening issue is part of it, that it's avoiding the cleaning up of the register, that by evergreening marks, that proprietors are effectively immunising themselves against any sort of attack for revocation. And by doing that, it allows them to basically clog the register and exert a monopoly, in this case too, against proprietors who probably have a fair claim to enter the market, but are just unable to do it because of the trademark situation.
I think that's a really interesting point, and it's a point I'm going to come back to. I just wanted to ask you in relation to that, or ask either of you. We had a case a few years ago where McDonald's did put evidence together of use in relation to Big Mac. And no doubt everybody knows about it. Big Mac. Maybe it says too much about me that I presume that everybody knows what a Big Mac is, but I do. I think that also speaks to the difficulty that that brand owners have in proving use in these situations, and might have pushed people more to an evergreening policy in order to avoid that difficulty. Is that a fair assumption?
I would agree. There is a certain amount of registry-led practice that as a result from this, but I wouldn't necessarily say it's so much from the non-use provisions. I think an initial problem that they found with this, and in the EU and the UK it's a particular problem, is that you can essentially file the trademark for whatever you want for the first 5 years, and there's no other than, yes, in the UK you have to have a bona fide intention to use, but that's never really tested, which therefore means you can have very, very broad specifications, which then a client, particularly a big client, they might want to keep having that broad specification because it's a very important mark for them. But in reality, they probably don't deserve that breadth of protection, because actually, so we take Big Mac as the example. Yeah, we all know a Big Mac, and it's probably a very reputable mark. But reputation provides an additional avenue for enforcement for McDonald's anyway. And when you look at McDonald's application, it covers many things they're not really selling under Big Mac. So they're selling, I believe it covers things like cheese. Now, yes, their burger contains cheese, but they're certainly not selling a Big Mac flavored cheese. And I think this is the problem, that whilst, yes, the non-use requirements can be difficult to overcome, and there certainly is a question of how a big entity that has lots and lots of marks maintains its records. But I do think this actually comes down to a larger question of parties filing very broad specifications, wanting to still maintain that protection somewhat artificially, and then not being happy that, they can't provide proof of use 5 years later. Well, sort of one leads to the other. If you just applied for what you really were going to use it for, you'd probably find demonstrating proof of use is a fair bit easier in that regard.
I suppose that point, which I take, although I think in my view it depends on the nature of your business and how easily you can predict what you're planning to do in the next 5 years. But it pulls us back to the Skykick series of cases that have been keeping the courts both in Europe and the UK busy over the last few years, and that's another question of bad faith and whether or not companies applying for marks that are clearly beyond the scope of their intentions should have those marks revoked for or invalidated for bad faith. I don't know, Emmy, is that something that you think or have a view on?
It is really interesting, isn't it, that bad faith over the last few years has become such a hot topic, and this is just the latest in a whole chain of cases where I would say that maybe 5 or 6 years ago we didn't think of bad faith as being particularly widely utilised. It wasn't a useful way of challenging someone's registration, but now it seems all of these avenues are open to us to look at what was really going on at the time of filing. And what the motivations might have been of the applicant at the time. And I think it's really sort of bringing home, isn't it, that what was happening at the time of filing needs to be recorded somewhere, and we need to be sort of mindful at the time of filing new applications why we're filing it, why we're filing for the specifications that we are, whether there are existing registrations, because there might be existing registrations that we don't even know about. You can be inadvertently evergreening, and then, all with a view to, in 5-10 years' time, you enforcing your mark and all of this being called into question. And I think one of the other interesting things that happened in Monopoly is that there was an oral hearing that looked at the motivation of why the applications were filed. And oral hearings just don't ever happen at the EU IPO, but it does make me think now that you have. That might be the opportunity at which your motivations will be called into question, and we might end up seeing more hearings at the EU IPO just to try and get to the bottom of what you were doing at the time of filing, why you were doing it, and whether you can sort of even recall any of this information.
I think that's right, Emmy, and that's interesting. I think it's another step that needs to occur for practitioners and for companies that file a lot of marks is auditing the process and the thought process and making sure that those are legitimate, because there can be legitimate reasons for these. I wanted to pick up a little bit on the point earlier in relation to this issue of the registry becoming overcrowded, and partly it's my recollection that the EU has always provided that you pay the same price for 3 classes of goods and services, and that's encouraged people to, where they know very specifically that they want their mark registered for a particular good or service that they are intending to bring to market or already have on market. It's encouraged them to widen the specification and to have their marks cover more ground than maybe they should. It almost feels like the EU IPO is kind of made a monster and is now trying to pull that back with bad faith, which maybe is a little unfair. I don't know, Harrison, if you've got a view on that.
Yeah, I mean, the 3 class, so automatic same price for 3 as it was for 1, did change sort of in the relatively recent past. So now it has gone back to just sort of 1 class, an additional fee per class thereafter. But I think the whole point remains, actually. I think the question still stands, because the additional cost for additional classes is not particularly significant. So even though there is now a cost, it's, if you were mindful of just going for as broad a protection as you can, it's not prohibitive to have additional classes unless you're a very small entity. And this matter, I don't think we're talking really about small entities generally evergreening. It's probably the, bigger entities. And yeah, I agree. I think it did, but whilst it did exist, it certainly wasn't helping. And I think they are certainly in a patch now where it's going to take a number of years to trim the register down. And I mean, perhaps we're moving that way, but as I said, it's still not that expensive, so you can do it.
I mean, thanks for clarifying, and it shows how long ago since I had to do that. But I also note that in the UK, you have to file a declaration of an intention to use, but the EU does not expect you to have to do that. So it might be that we see a divergence in the approach that's taken from the UK and the EU post Brexit, and I got the feeling from Skykick that would be something that the UK judges would be keen on. But I don't know, Emmy. You manage worldwide portfolios. I know the US system is very different. Do you think that's where we're going to end up? If you could tell us a little bit about the US system, do you think we'll move towards that, or will the EU despite all of this, keep resisting that?
we keep talking about it, don't we? So the US system requires you to file a declaration of use and provide specimens of that use periodically in order to maintain your registration. So you'd be looking at filing a declaration of use 5 years after registration. So that's obviously in line with our five-year grace period in the UK and EU. And I think that there is regular talk about introducing a US style system where you have to positively maintain your registration by showing use, rather than, as it currently is, you wait until you're challenged. And there's obviously a really key benefit to it, which is that it's very clear on the face of the register what the scope of people's rights are. So when you're clearing marks or trying to introduce new brands into the market, you can look at the state of the register and you automatically know that, within that period of 5 years, whether that mark is being used or not, and how legitimate any claim against your use might be. Which I think is, the common problem in the UK and EU, that a newcomer to the market simply doesn't know on the face of the register whether those marks are enforceable against them or not. And it takes quite a lot of additional time and expenditure to find out. So I think that there is a benefit to the US system. Having said that, it's an incredibly different system. And I think that there's a real sort of a pushback to changing our practices, so widely. And to moving towards a system which is so different to what we're used to. Of course, the other aspect of the US system, which is so different to ours, is the very specific wording that has to be used in specifications. So it would, if we move to a US system where we also employed that, then it would also, we would eliminate sort of very broad wording. So you wouldn't be able to have clothing, for example. You would have to itemize your clothing into t-shirts and shorts and all of that kind of thing, and that can be helpful too. So I mean, when we talk about the US system, I suppose we could take a bit of a pick and mix approach, couldn't we? We could either go for that sort of maintenance obligation or look at a higher degree of specification in the goods and services, and I think either one of those would be helpful. But I still think it might be unpalatable, I think, to brand owners in the UK who are very used to the way that we've always done things with broad specifications.
Thanks, Emmy. I'm aware of the time, and whilst I'm happy to spend hours talking about trademarks, I'm not sure everybody will have to spend hours listening. It feels like, for me, the takeaway from what you have told me is, or one of those takeaways, is that people need to take use seriously, not presume evergreening is going to work for them, and because you might end up with rights that you think you can enforce because they are within the 5-year grace period, and they can't, because of these bad faith arguments that will appear more and more as those marks are enforced, and also not to presume that all of the trademark systems operate in the same way, that we're applying similar rules in different ways, or the same rules in different ways, and that can lead to quite significant changes. Is that a fair assessment? And are there any other things that people can bear in mind or should bear in mind in light of specifically the Hasbro monopoly case, but these developments?
I mean, I think that is a fair assessment. I think that covers many of the conclusions that I think can be taken from the case. I think one particular aspect that I think is also worth noting, and sort of appending onto that, is how perhaps owners enforce their rights. I think that was a very noted point in the decision, that actually the practice of relying on the new registration to take action where you have the older rights that could be put to proof of use was one of the factors indicating bad faith. And I think, I mean, you'll know this, Mark, obviously in your field, but I'll be curious to see how people decide to enforce their rights going forward, and if they have to be mindful of that, about not, filing new ones and then just relying on the new marks so as to avoid it, because I think that could well in turn bite them, because it could be as evidence of bad faith.
I think that's absolutely right, and that's going to be very interesting when you put that together with the pressure that you might get, let's say, in IPEC, where there is a focus on choosing your best mark and not taking up unnecessary court time with other marks which aren't really adding anything to the argument. So when going through that process, it feels to me that claimants will need to say, yes, this might be the best mark, but is that going to lead to a suspicion that I've chosen that mark because it's in the grace period? Should I run another mark as well that is the same mark but with slightly different specification, just to show that I can prove use and I'm not using that one for bad faith purposes. But it'll be interesting to see how that works out. Emmy, I don't know if you've got any kind of final remarks on all of this.
Yeah, well, I agreed with your summary as well. I think there was one other point which I thought was also worth noting, which is that this is obviously bringing some question of sort of the timing of your use. It's going to become more important to evaluate what your likely timing is of commencing use of your mark when you go about filing it. So, obviously industries where there is a long lead time to actually getting your product onto the market. So the pharmaceutical industry is an obvious example. You need to be bearing that in mind at the time of registering your mark, that if you're not going to be able to show use and your mark is going to become vulnerable before you're able to show use, then there might be an advantage to holding off from filing, because you're not going to be able to necessarily benefit from the evergreening, which might have been your way out of that problem previously.
Yeah, that's interesting, isn't it? I know pharmaceutical companies do have lots of marks ready as they go through the approval systems that are necessary to launch pharmaceutical products, both from a trademark and naming sense, and obviously from a pharmaceutical and medical sense. I suppose that might be a challenge for them, because that feels to me that's something that is inherently not bad faith to file those marks and have them there, but to enforce them is when that will get tested. And if you are a pharmaceutical company with a 10-year-old mark that you've never used, but you're enforcing it, then you may well be vulnerable now.
I can imagine so, but it is also interesting, isn't it, that because bad faith is developing so rapidly over the last few years, that I can well imagine that these sorts of circumstances might be seen before the courts, and various exceptions might be made and that kind of thing. And of course, the other thing is that there is still further appeal for Hasbro in this particular case, so we might still see an appeal in the monopoly decision. I don't know, what the CJEU might make of an appeal, but it is something to keep monitoring, and the whole circumstances around bad faith and what that might mean, I think is still susceptible to quite a lot of change over the next few years, really.
I agree. Sorry, Harrison, carry on.
That's all right. I was just going to say, as a final thought, actually, I don't know what either of you think of this. It just occurred to me. But in the pharmaceutical situation, part of me wonders whether a pharmaceutical entity might decide to file it in a stylized form first, give them not quite as broad rights, but then once they actually know they're going to launch it, or it's far more, in more the immediate, 1 to 3 years rather than 5+ years away, then filing their word mark name, so that, yes, because it's important to remember with this, that evergreening only relates to the identical mark. So therefore, filing a new application in a word form, if you've only got a logo previously or vice versa, won't be caught by this requirement. So perhaps companies have to start thinking strategically about what the first mark they file, and perhaps they file a slightly weaker mark in order to be able to, in the pharmaceutical scenario, file their stronger mark later when they know it's going to be in use and defendable.
And so I suppose I have a quick response to that. One is the principles of bad faith that are in Hasbro could equally apply to doing something where you're trying to evergreen it in a slightly different way, because it's all about the intentions of the parties at the time of filing. I don't think it's plausible for someone to extrapolate that. And you're shaking your head, Harrison, but to extrapolate that and say, okay, so you filed a word mark and now it's a slightly different mark, but we know you're just seeking to extend the protection of that previous mark. Is that unfair?
Slightly, only the current precedent, and obviously Brexit aside, and what Mr. Arnold or someone in his camp might make of it is yet to be seen. But currently, the precedent for this particular aspect only relates to that same mark. So, because otherwise, if you apply the evergreening criteria to all marks that have been filed, such as that, then you can say, well, if you filed a word mark, then filing your logo some years later, or filing a new version of your logo, are you just trying to evergreen? Are you actually going to change your stylization? It could almost become this block that prevents you from rehashing your mark or rebranding your mark after a number of years. I think that at the moment, the precedent only relates to filing the same mark for the same goods and services. Whether that expands is an interesting question to go forward, but there would be negative connotations if it was to expand as well, I think.
I think we might see more challenge to that though, because I suspect that we might end up seeing more applications filed by sort of shell companies effectively, in order to disguise possible evergreening. So I think that the possible ways of circumventing these earlier decisions and the rules that are sort of being created very ad hoc around bad faith, I think that it's going to become harder and harder to sort of act in bad faith in a way that is not immediately obvious. I think people will start looking behind some of this stuff in more detail. It'll become harder to do, but I like your thinking, Harrison. I think it's it's a creative solution to quite a tricky problem, isn't it?
I think I should state here that I'm not in any way condoning acting in bad faith. It was more just what might be a practical solution, particularly for some industries like the pharmaceutical ones, where I think they are faced with limited good options at this point, particularly if in these situations.
Yeah, it's certainly difficult for them to know where they stand right now, isn't it?
So thank you both. I mean, I think what's definitely clear is that this is an evolving area and something that people need to pay attention. And it's probably clear to everyone that we could spend too much time talking about it. But to those of you who have stayed with us, thank you very much for listening. Thank you to Harrison and Emmy for that, I thought, very interesting discussion. If you have enjoyed it, there will be more Potter Clarkson podcasts coming your way soon. And with that, we'll say goodbye. Thanks, Harrison. Thanks, Emmy.
Thank you.
Thanks, Mark.